All right, I believe we are ready to go. We are back in session. And our next case is Valles versus Mueting et al. At this juncture, let's do a quick sound check, and then we will proceed with arguments. I'm going to start with Ms. Penner. It's my understanding you will share your time with Mr. Settles. Is that correct?
That's correct.
Thank you. And I can hear you, and I can tell you can hear me. And Mr. Settles, I want to make sure you can hear me.
I can hear you, Your Honor.
Thank you. And the plaintiff is represented by Mr. Braley. Can you hear me, Mr. Braley?
Yes, I can, Your Honor.
All right, thank you. So I believe, and also I believe Sarah Dempsey is accompanying Mr. Settles. So yes. Mr. Braley, you may begin.
Thank you, Your Honor. May it please the court. My name is Bruce Braley, and I represent the appellant in this case, Rosalinda Valles, and her minor child, Francisco Lopez. Francisco was 11 years old when the events that bring us here happened, and he'll be turning 16 next month. I want to begin briefly by restating the relief we're requesting the court to provide in this case. First, we're asking the court to reverse the summary judgment entered in favor of Dr. Wingert and Dr. Ryder, and asking the court to remand for a trial on the merits. We're also asking the court to grant a new trial in the claims against Dr. Joseph Lever and Dr. Andrew Mueting, based on an erroneous instruction that was not given on the duty of a specialist in a medical negligence case. We're also asking the court to reverse the summary judgment barring our client for pursuing past damages for medical and hospital expenses paid by Texas Medicaid under Iowa Code Section 147.136. And we're asking the court to rule that the trial court should have granted a directed verdict on the claims of comparative fault involving Mercy Hospital when there was no evidence to support that claim being submitted to the jury, and for the other relief we've requested in our briefs. I'd like to also start by briefly addressing the jurisdictional issues raised by the appellees in this case. As a matter of law, the trial court's order on November 21st of 2018 was not a final order for appeal purposes, and this court's ruling creates the law of the case doctrine to prevent that issue from being revisited.
Wasn't it a final order for those doctors, and I believe it was Northwest Iowa, wasn't it final for them? I realized there were other defendants outstanding still who needed to be buttoned up, but wasn't it final for them?
No, Your Honor, not under the rule, which requires in a case like this with multiple parties and multiple claims, until final order on all adjudicated claims is entered, it would create confusion and problems for this court if you could piecemeal appeal various claims when there is not a final resolution, which there was not in this case.
You must not be wholeheartedly convinced of that, though, because you filed what you referred to as a protective notice of appeal or something. So it must have some grayness in your mind as well.
Well, that's why we did it, to make sure that there was not an issue, and this court properly ruled that it was not an issue that was timely before the court, and that court's ruling should be the law of the case and not subject to review at this time.
But was that motion or that first notice of appeal? It says that you appeal to the Supreme Court the order and judgment entered in this case. It didn't say final judgment. Was the court misled at all as far as who was still out there and what had already been resolved?
No, not at all, Your Honor. In fact, the court asked us to clarify the jurisdictional issues, which we did. And we were always transparent about what our concern was and our belief that the jurisdictional issue was not timely, but in order to protect our clients' rights, given the fact that an order had been entered as to 3 of the defendants, we filed a notice and then made clear in the notice that we did not believe that jurisdiction was proper, which we also presented to the court when we were called upon to do so for clarification.
Mr. Braley, this is Justice McDonald. Under the doctrine of pragmatic finality, why isn't the voluntary dismissal later on considered the essentially the pragmatic final order from which the time to appeal would run.
Your Honor, I think that that's directly addressed in the Countryman decision, which said that dismissals by parties are not considered a final judgment, which is why we then asked the court, after those dismissals were filed, to enter a final judgment that could adjudicate all remaining claims and allow jurisdiction to vest in this court at the time we filed our notice of appeal.
That's interesting because I read Countryman, at least as applied to the facts of this case, going the other way. And I guess I would ask you if it's your belief that until there was an order entered, when would would the case never be final? So for example, let's assume you file this voluntary dismissal, but the court doesn't approve of it until a year, 18 months later. I take it your position would be you'd still have 30 days to appeal from that final order, regardless of the delay between the time of
Yes.
dismissal.
That
Okay.
would be our position, Your Honor.
Thank you.
To start my argument on the merits by talking about the summary judgment that was entered by the trial court in favor of Dr. Wingert and Dr. Ryder, and begin with the framework for the court to follow in addressing that issue. And Justice Waterman used the same analysis in the Plowman case by noting that it's long been the practice of courts in Iowa that medical malpractice claims are not ordinarily susceptible of summary adjudication, and that the existence of a physician-patient relationship should be a question of fact to be decided by the jury. And that goes with the longstanding notion that the court should indulge every reasonable inference in favor of the resisting party to ascertain the existence of a fact question. Plowman also noted that a contractual relationship between physician and patient is not required in order to establish a duty on the part of the physician. And I want to address a specific concern I have about the affidavits filed by both Dr. Wingert and Dr. Ryder. A statement of custom and practice by a physician who has no memory of the events that happened is not an undisputed fact. It is merely circumstantial evidence that allows a jury to infer that that statement they're making did in fact occur on an actual date. I have a custom and practice of taking the garbage out to my curb before I go to work on Friday mornings. But that does not mean it is undisputed that the garbage cans wind up there every Friday morning. So when looking at the affidavits of both Dr. Wingert and Dr. Ryder, the court needs to compare that to their sworn deposition testimony that was provided months before they provided their affidavit.
The custom and practice evidence that was in the form of an affidavit, it is evidence for the court to consider. The plaintiffs, though, I mean, obviously the defendant can't prove a negative, but what evidence do the plaintiffs have? For example, the page. There is no evidence that it was actually received, is there?
There's significant evidence, Your Honor, and the only undisputed evidence is that Dr. Wingert was the on-call physician for the pediatric floor from noon to 6 p.m. But what is strongly disputed is what she knew about Francisco Lopez's condition and what she did about it. So,
okay, but that's the standard of care. I want to get back to that doctor-patient relationship. What evidence? I don't doubt there's evidence by the plaintiff that a page was sent. Let's just assume that. I am talking about received. What evidence does the plaintiff have that that page was received?
Well, the plaintiff has no ability to reconstruct the page because no records were produced of the paging communications. And Dr. Wingert never said that she didn't see the page ever occurred. She testified in her deposition she had no memory of the events of that day. So how can she say she never received a page? And in fact, we brought up to the court during the summary judgment hearing, Dr. Wingert said in her affidavit that there was a procedure in place at the hospital where if a nurse could not reach a physician by a page, they were to call him on their cell phone. And as we pointed out to the judge in the summary judgment hearing on volume 2, page 114 and 115, we had requested on 2 separate occasions any evidence to support that that procedure was in place before the hearing occurred, and had received nothing from the defendants. So that again is circumstantial evidence that contradicts the statement that Dr. Wingert makes in her affidavit. She also provided inconsistent testimony in her affidavit saying that Dr. Neuenhaus didn't tell her she needed to see Francisco, but she testified in her deposition she had no memory of ever talking to Dr. Neuenhaus and had no memory of the checkout report he gave her. She also, one of the most important factors, Your Honor, that is a disputed fact, is Dr. Wingert does say in her affidavit she got this checkout report at noon on April 7th from Dr. Neuenhaus. You have to look at the context of when she received that checkout report. Dr. Neuenhaus was in Francisco's room less than a half an hour getting a report from Nurse Sandra Lang identifying his deteriorating neurologic status, including the nurse physically demonstrating his eye deviation, which was a significant neurologic change, the fact that he needed assistance with walking, the fact that his eyes were twitching, and all of these things were reported to Dr. Neuenhaus right before he gave his shift change report. And a jury could infer from that Dr. Wingert knew of those neurologic changes. She knew she was the only physician assigned to provide care for this patient. And Dr. Neuenhaus and 4 other physicians already had, as part of their differential diagnosis, the possibility of meningitis and a plan of care to get a lumbar puncture if his condition didn't improve or change, which is exactly what Dr. Neuenhaus learned from Nurse Lang.
I have another question about the page,
Yes.
and then we can move on to something else. Okay, so there's quite a bit of evidence that there's a dead zone in this hospital, and when doctors were paged, if there was a problem, then they were supposed to be called. Was there any work by the plaintiff investigating dead zones in that hospital?
Yes, Your Honor. The work was, we asked the hospital's attorney and the attorneys for the family practice residency program to provide us any evidence that they had a procedure to address that problem, and received nothing in return. There was no way we could go on site at the hospital without permission to test that. And the responsibility for backing that up is the defendants in a summary judgment hearing. But the most important piece of evidence that we brought to the court's attention is the audit trail evidence. Dr. Wingert went off shift at 6 o'clock. She promptly called her faculty supervisor at 6:01. And at 7:11, and this is in volume 1, pages 1641 to 1643 of the appendix, the audit trail is generated every time a physician or nurse enters an electronic medical record for a patient like Francisco. And at 7:11, the very first audit trail entry identifies Dr. Wingert as the provider, Francisco Lopez as the patient, and the event is described as a patient-provider relation. Then on page 1642, Dr. Wingert is reading the clinical diagnoses for Francisco Lopez, reading the problems, and reading the flow sheet, which the nurses enter in the patient's chart. There were 7 entries in the audit trail. On page 1643, there's 6 entries involving Dr. Wingert. She's reading the clinical diagnoses. She's viewing the orders. She's reading the procedures that have been performed. And most importantly, she's reading the care plan. The care plan is the plan in place to get a lumbar puncture if his condition deteriorates or doesn't improve. And she had to have seen that when she was in the audit trail, and yet she's claiming she has no physician-patient relationship. She was supposed to give the same type of checkout report to Dr. Swampalai at 6 o'clock, and yet Dr. Swampalai testified in her deposition that she never received a checkout report from Nurse Wingert. And the court should be asking, how could you give a checkout report if you have no information about a patient, you provided no care, you claimed you didn't look at their chart, and yet here is a patient with a life-threatening potential disease and a possibility of getting a lumbar puncture, deteriorating neurological signs, and she does nothing. So the question in this case for the court is whether a physician who's on call with primary responsibility, given all of these facts that could create a duty that were disputed, that is clearly a basis for not allowing summary judgment to be entered and letting a jury to decide whether a physician-patient relationship existed. And I'm about to run out of time, but I thank the court for its time, and I'll look forward to talking to you more in my rebuttal argument.
Thank you. I'm not sure if Ms. Penner or Mr. Suttles is going to go first, but I'll let you decide.
Your Honor, may it please the court, I will go first on behalf of trial defendants, Dr. Lever and Dr. Mueting. Plaintiffs raised 4 issues as to the trial defendants, 3 of which concern matters the jury never reached: causation, comparative fault, and damages. On the one issue that even remotely possibly addresses the no negligence finding on behalf of the trial defendants, Dr. Lever and Dr. Mueting, there's a reason set forth in our brief that argument fails to warrant a new trial. I'd like to address first, however, the threshold jurisdictional issue. There is a few things that qualify as a final judgment under the rules as defined and under the case law, other than the final judgment entered in this case on November 21st, 2018, after a 4-week jury trial, a jury verdict, and a final judgment entered on the same day. There has never been any indication of anything that the trial judge needed to do as to the appeal defendants after that judgment. Plaintiffs have never identified anything that was left that the court needed to address. It was intended to be a final judgment. The court, in that order, assessed cost against plaintiffs, among other things. The only thing, and so if November 21st, 2018 is the final judgment, plaintiff's appeal was due in 30 days. The current appeal before the court was filed about 6 months later. It's our position it's untimely. Plaintiff's only argument is that they had settlements to complete and dismissals to file as to 7 settling defendants. However, if you look at the case law and the rules, the voluntary dismissals don't trigger an appeal. And there's no necessity for a court order for a plaintiff to voluntarily dismiss some defendants. Plaintiffs manufactured a final order after they dismissed the remaining settling defendants. And we submit that May 2019 quote unquote final order or judgment adjudicated nothing. The trial
counsel, what was the effect of our court's ruling saying this interlocutory appeal is premature, that we denied that? Was that just our head fake?
Your Honor, we believe subject matter jurisdiction is something the court can revisit and must revisit. And that context of that was the court's request for briefing, and plaintiffs in response asked for the appeal to be dismissed without prejudice. There is no such thing under our appellate rules. So instead, the court treated it as an interlocutory appeal and rejected that. The court respectfully did not analyze the issue currently before the court. It simply, under the rule, treated it as an interlocutory appeal and let plaintiff have a second chance, and we'd respectfully submit reserved the jurisdictional issues for now. we'd also do not believe this is a pragmatic finality case. The key cases on that in Iowa, Alls and Countrymen, concerned an early order in the case, summary judgment for one defendant, another order disposing of one defendant, and all the other defendants in a multi-party case then were settled out. And therefore, there was no final order. There was nothing to dispose of the case finally in the district court. And this court
Counsel,
exception.
if I may, what do you make of the plaintiff's argument, though, under Appellate Rule 6.101 sub 1 sub D? You can go ahead.
Our position is that the May 2019 order that was essentially manufactured by plaintiff was not a judgment that finally disposed of the case. Judgments are an adjudication under the rule 1.951 of Rule of Civil Procedure. A judgment is defined as a final adjudication. That district court in May of 2019 adjudicated nothing.
Let me ask a question quick about that. And you know the record much better than I do. Did the defendants object to the plaintiff's request for that special order that you're saying is manufactured?
Your Honor, plaintiffs filed their dismissals, then they filed the request for the order on May 28th. And the district court with a proposed order for the court to enter, and the court granted that the next day prior to any opportunity for us to raise this issue. So our position is that the May 2019 did nothing. That order did nothing. It was not an adjudication. It was not a judgment. The settlement was approved by a different court, the probate court. And the issue, it matters. It matters to defendants. And plaintiffs resolved their issues sufficiently with the settling parties to dismiss them within about 6 months. There's no guarantee that was going to be the case. This involved negotiations with Texas Medicaid, apparently. It could have involved litigation with Texas Medicaid. It could have been years before all of that resolved. And a party with a final order after a jury verdict has to wait for years. We respectfully submit that's too long and it's unfair. And plaintiffs could have, they filed a notice of appeal after the November, timely after the November judgment, and had second thoughts and weren't sure. Plaintiffs, there was a solution to this. Plaintiffs, after they were sure that they had finished what they needed to with the district court, so the district court did not lose jurisdiction, they could have, if they were concerned, filed another notice of appeal after the May 2019 dismissals and asked this court to consolidate those two appeals. If there really is, in some cases, a difficulty in understanding what the final order is, there's an easier and a more economical way to resolve this rather than hold the winning party, the defendants, trial defendants, hostage for years waiting on a final order and appeal.
So,
Ms.
Ms. Panda-
Penner, this is Ed Mansfield. I wanted to ask you about a subject that hasn't come up. I just want to make sure I get a chance. The expert report of Dr. Meyer, such as it was only about a page long. And then he testified very extensively at trial, very critical defense witness, it struck me. And your argument as to why that's not really a viable appeal issue is, well, it was really only on causation and not negligence, but aren't those inextricably intertwined? In other words, the doctors couldn't be negligent if the meningitis wasn't detectable until the 8th of April. So, I mean, it seems to me those two issues are completely connected. And on that basis, I'd like to hear from you as to why you think this expert report was sufficient by Dr. Meyer.
Your Honor, under the facts of this case, causation and standard of care and whether there was negligence are not so connected that Dr. Meyer slipped into a negligence or a standard of care expert. The opinions from plaintiff were that Drs. Lever and Mueting should have done an LP and ordered antibiotics upon the suspicion of meningitis. Whether or not it was confirmed with the radiology evidence, et cetera, that Dr. Meyer was discussing. So causation was a very separate issue at trial with intensive infectious disease experts as well as the radiology experts. So we don't believe that the two issues meld or that he touched on standard of care. He clearly testified he was not talking about standard of care. And Your Honor, it is a matter of discretion with the trial judge. This trial judge looked at the opinion. He considered carefully extensive argument from plaintiffs. He took a recess and studied the Iowa law on the issue, and he sustained some of plaintiffs' objections to Dr. Meyer. But Dr. Meyer's direct exam painstakingly went through and connected his trial testimony to his report. It was a broad opinion, but
Counsel, were plaintiffs surprised or prejudiced by the extent to which Dr. Meyer's trial testimony went beyond his written report?
No, they were not. Jury never reached causation, but also plaintiffs responded completely with their own expert before Dr. Meyer testimony. So there was, plaintiffs were not surprised by the content. And I need to reserve time for my co-counsel, and thank you. And we'd ask the court affirm. Thank you.
Thank you. You may go ahead, Mr. Settles.
Thank you, Your Honor. May it please the court. My name is Bill Settles. I represent Dr. Wingard and Dr. Ryder. And I want to start with the question that was raised about this court's interlocutory order dismissing the initial appeal and try to put that in some context. At the time that the court required a statement of jurisdiction and entered its order dismissing what it characterized as an application for interlocutory review, the settling defendants had not yet been dismissed. So on an initial review of the case, it certainly could have the appearance that there were issues out there that were outstanding that needed to be dealt with. After the court dismissed the pending appeal, then on April 15th and April 30th, the plaintiffs dismissed those settling defendants from the case. And at that point, of course, our position is that the judgment that was entered on the verdict was the final appealable order. But even if you accept the view that these issues with the settling defendants needed to be dealt with, those issues were resolved at the latest by April 30th of 2019 when the dismissal was entered. The request for a final judgment was simply a device whereby the appellant could extend their appeal date. And that
Counsel, if I might, could you turn to the question of the doctor-patient relationship with Dr. Wingard and Dr. Ryder?
Yes, Your Honor. Well, the argument is that a physician-patient relationship, the existence of that relationship is an issue of fact. The facts in this case with respect to Dr. Ryder certainly are not in dispute. She was not on call for this service. She was not on call for a service that would include this patient. So the fact that she was contacted and given a report about the patient and then declined to treat the patient because she wasn't available because she was taking care of another set of patients, none of those facts are in dispute, and that certainly doesn't give rise to a physician-patient relationship or the type of relationship that would impose a duty of care. Dr. Wingert was on call for this patient. She did not, however, have primary responsibility for the patient. That is a misstatement. The primary responsibility for the patient is with the faculty attending physician. Residents operate under the supervision of their attendings.
Mr. Settles, this is Justice McDonald. Could you address Mr. Braley's argument regarding the audit trail and how that potentially creates a fact issue on the relationship, on the duty?
Well, as I understand the audit trail, all that shows is that Dr. Wingert accessed the patient's chart to review it after her shift ended, after she was no longer on call, during the shift when the page at issue was sent. That certainly doesn't establish the existence of a physician-patient relationship during the period of time that she was on her shift. She initially contacted her attending, and shortly after her conversation with the attending.
Does her being on the shift matter? So if the records indicate repeated access to the medical file to look at the records for the purposes of treatment, is that enough? Even if it was after her shift?
Well, I don't know that the audit trail discloses that she accessed it for the purposes of treatment. She certainly didn't enter any orders, perform any exam, undertake any kind of affirmative action to provide treatment to the patient. I think the more reasonable interpretation of those facts is that she spoke with her attending and was consulting with the chart because she had been made aware of this patient and was preparing for her shift the next day.
Do you know, can you tell me when Dr. Wingert was looking through the records through that audit trail, if it was after her shift, does the record show that at that point when she started looking at the records, another doctor had become the attending doctor or was taking care of the child?
Well, I'm not certain if the records show that specifically, Your Honor. I'm not familiar enough with that specific issue, but certainly another resident would have come on call, and Dr. Swampali would have been the resident who took over. And as Mr. Braley pointed out, should have received some sort of update on this patient if in fact Dr. Wingert was familiar with the patient and had been involved in his care, which was not provided. So I think to the extent we can determine who became the resident on call for the patient, it would have been Dr. Swampali. There is, of course, a faculty member who is primarily responsible and who is in fact the attending physician, but I'm not familiar enough with the record to say who that would have been.
Go ahead.
I'm sorry, Chief, could I ask a question? Is it your position, Mr. Settles, that you're the physician on site, you're the physician on call, you're contacted with a question about a care about a patient, and yet there is no duty of care to that patient? Is that your position?
Not precisely, Your Honor, because in this case, Dr. Wingert was not contacted. Dr. Ryder was contacted, but was not the person on call and declined to become involved in the patient's care because she did not have that responsibility. I mean, the central issue here really is is Dr. Wingert's status as an on-call physician. Is that in and of itself enough to give rise to a duty of care to this patient? And our position is that it's not. It takes more than that.
On behalf of defendants, you may wrap up.
Unless there are other questions, Your Honor, we'd ask the court to affirm the judgment of the district court.
Thank you. Mr. Braley, would you like to respond?
Yes, please, Your Honor. First of all, I want to address the question of who had responsibility for taking care of Francisco Lopez between noon and 6 p.m. on April 7th. On volume 1, page 1534 of the appendix, this is the deposition testimony of Dr. Wingert. I would have taken care of any of the family medicine patients that would have come into the ER at Mercy. I would have also covered the floor if there was any calls or questions about patients on the floor. And by patients on the floor, she meant on the pediatric floor, which was Francisco Lopez. This was not the duty of a faculty member. She was the one on call. She was the one responsible for being there.
But isn't the key phrase would have, that she needed to know about it? Isn't that the rub, that she's saying, I didn't know that they were looking for me?
Well, that's her position. And we're telling the court what we told the trial court, which is that is a disputed fact, because she claimed there was a policy in place to deal with that, and they never produced a procedure that would support it. She also was armed with the knowledge of that checkout report. There's no dispute about that. And the inference the jury can draw from Dr. Neuenhaus's knowledge at the time he gave the checkout report was this is a patient with deteriorating neurologic condition. But I also want to focus on Dr. Ryder, because there is a stark difference between what Dr. Ryder says in her affidavit and in her sworn deposition testimony, which preceded it. Because she testified she had no knowledge, no memory of what happened when she was called by Nurse Lang. And yet she tries to construct that she was not asked to provide information and that she told Nurse Lang she would help her identify who the resident on call was. That's preposterous. Nurse Lang knew who the resident on call was. It was Dr. Wingert. That's why she paged her early in the afternoon.
When Nurse Lang paged and she was deposed, did you ask her about the policy? What do you do after a page? Was that asked in your deposition?
No, because her deposition was taken before Dr. Ryder's deposition and Dr. Wingert's deposition. So she was asked extensively about her conversation with Dr. Ryder, and she testified, I went through everything that I told Dr. Neuenhaus. I went through the gait problems. I went through the spike in temperature. I went through the eye deviation. I went through the frontal headaches. Those are all neurologic signs and symptoms of a deteriorating patient. She told that to Dr. Ryder, and Dr. Ryder's response is, not my patient, not my problem. And she tries to justify that by saying, I wasn't the one assigned for call for this patient. But why would Nurse Lang go through that litany of those neurologic symptoms if Dr. Ryder had told her that? And she also makes the point in her affidavit that the fact that she wasn't on call justified her not responding to this page. But what did Dr. Neuenhaus do? He eventually returned the call after Dr. Ryder was paged and talked to Nurse Lang. He had no obligation. He wasn't the on-call physician, but he felt a responsibility to this patient, armed with the knowledge that he had a life-threatening condition and could have deteriorating neurologic symptoms, to accept responsibility and step up. And it's not just the affidavit and the deposition testimony. We had also provided expert opinions that both Dr. Wingert and Dr. Ryder had duties as a physician, armed with this knowledge, to do something to help this child. Dr. Ryder was taking care of pediatric patients that day at Mercy Hospital. She didn't have primary responsibility to take care of patients on the pediatric floor, but she was clearly taking care of pediatric patients. I know we're here today to discuss the law because that's what appellate courts are designed to do. The decisions you make in this case will impact two very real people, Rosalinda Valles and Francisco Lopez. So I invite you to go to volume 3, pages 575 through 584 of the appendix, and take a look at what Francisco's life was like before this happened and what it's like now. The issue for this court to decide is whether not my patient, not my problem should be the law in these circumstances. Thank you for your time.
Thank you. And the case of Valles versus Mueting et al. Is hereby submitted, and court is adjourned until this afternoon. Thank you.